Welcome to John Redmann, Power of Attorney, the show that aims to empower you through knowledge of the law. I'm attorney John Redmann.
And hello, everyone. I'm Shauna Sanford. So great to have you with us today. Well, we are continuing our conversation about workers' compensation. Now, last week, we learned that there is actually a law in place to protect businesses against fraudulent workers' comp claims. But there really isn't anything in place to give employees that same kind of protection.
Shauna, not only is that true, but it's also true that until recently, a business owner could actually sue an employee in court if the owner thought he or she might be filing a false claim.
Really? The employer could actually sue the employee?
Yeah, which was one of those things that lawyers like myself thought was just really ridiculous and unfair. Put an unfair chill on the system. But that's been changed. If the employer thinks you're filing a fraudulent claim, they can still actually take legal steps against the employee. But what law was in place before was overly broad, and that's been reined in a lot. And so we think that's a very positive step, and it's good for everybody. It's good for businesses and employees.
Yeah, and there actually have been a lot of changes with the various laws concerning workers' comp.
A lot of changes, and we have Mr. Ray Murray back here again to talk to us about that. It's going to be another excellent discussion.
Another great show, and when we come back, Attorney Ray Murray returns to the show to explain the rights of employers and employees when it comes to workers' comp. So don't go anywhere. We'll be right back.
It's full of statistics. Thing is, I could have dropped out of school and become one myself, but I didn't because I had people that believed in me. Here's another statistic. 7,000 students drop out every school day. That's one every 26 seconds. It's time that students know that we believe in them.
Inspire a student and share your message of support at boostup.org.
Hello, everybody, and welcome back to the show. Thanks so much for being here. Now, I don't think we can ever underestimate just how important it is for everyone to know their rights when it comes to dealing with legal issues, especially workers' comp, which is what we are talking about today. Now, here's something you might find very, very surprising. Until recently, if your boss thought that you were going to file a false claim or receive benefits fraudulently under workers' compensation, he or she could actually take you to court. And John, I'm sure that everyone at home is wondering how this could actually happen.
Well, it sounds incredible, but it's true. And joining us today for this second episode and to explain this bizarre law and other recent changes in workers' compensation law is my friend, Attorney Ray Murray. So, Ray, why don't you just, before we get into the meat of the discussion about the whole topic for today, tell us what happened. There was a law that seemed to have a lot of scary parts to it for employees out there in general, but recently it was kind of reeled back. Well, tell us about this.
That's right. Well, thank you again for having me back, Shauna, and thank you, John. Yes, out of the 2012 session, I think it was, that we had Act 860, and what the law had been expanded to say was that an employer could sue an injured worker for any reason. The law had a lot of bad ramifications, such as making people afraid to even report a claim because you might be sued. They could sue you for, I believe it said anything, any reason. So any dispute they wanted to formulate. Recent enactment, we had Act 860, which was actually sponsored by Senator Jack Donahue. We had Representative Greg Cromer sponsored a bill, Act 337, that went through. Now the employer can sue the injured worker and take them to court if they believe that they're receiving benefits fraudulently, if they've suffered some type of harm. But it can't be speculative as it was under the previous law, where I think you may be doing something wrong and therefore I'm going to file a filing in court against you and cause injured employees to have to defend claims. Or maybe, as we talked about in the last session, the person doesn't even want a benefit and the employer was still able to sue them. And based on that, the law was reeled back greatly in Act 337.
I'm glad to see the legislature can get some things done right. It sounds like that was a positive, and that was a what do you call it? Democrats and Republicans coming together to make that happen.
Yes, it was. The bill, Act 337, also covered Act 860 had created a telephone judge process, and we re-examined that with some legislators and along with some of the people from the administration, and we came to a decision that maybe there was a better process, which is now being enacted. It went into effect August the 1st.
You were one of the people very active in helping to make that happen. That's what I understand from my informed sources. So thank you for working on that.
So
It takes a lot of time.
Just to be very clear, an employee can still sue an employer, but that employee has got to have some concrete evidence that, in fact, the employer has filed a fraudulent
No, the
claim or is
employee.
receiving
No, you're saying it backwards.
the employee.
The employer can sue the
Employer
employee.
can sue the employee. Thank you, but there has to be some concrete evidence.
I don't think it's concrete evidence. I think that they need only to make that allegation
Oh, okay.
actually to file your. But I'd also like to touch on the point that a lot of times injured workers don't understand there are only 4 reasons you can file a suit in workers' compensation. And that is you've not been paid the wage benefits you're due, you're not receiving your medical treatment, you've not received medical reports, or you're entitled to penalties and attorney's fees. Those are the only 4 allegations allowed. And if anyone was interested in looking up the law on the internet, look up 231314. It's that would be your law.
23:13:14, and that's in our Louisiana revised statutes.
That's correct.
And if you go to the show website, we're gonna have links put up there. You'll be able to see a lot of the verbiage of these laws. It's really not that complicated. And for those of you who are wrestling with these interesting areas of law, or you're somebody who's injured and you want to know your rights a little in more detail, go to the show website and we'll have that information and a lot more detail for you to see.
And when we talk about fraudulent claims, I mean, that word fraud, I mean, it could be sort of wide-reaching, can't it? I mean, an employee perhaps could be doing something not necessarily realizing that they are violating whatever the terms are of filing that claim, correct?
Yes, ma'am. Fraud can be found under 23:1208. And you should take the time to read it, especially if you have a workers' compensation claim, because it says that any statement intentionally made that is made for the purpose of obtaining a benefit can be fraud, and you can lose not only all your benefits under your workers' compensation by making a false statement or misrepresentation of fact, that you may also be subject to criminal charges.
Give us an example of where somebody is committing fraud where you say that's justified. This person's really trying to commit fraud to get benefits, and other examples that you've actually seen where the employer's trying to press an advantage, where somebody made a statement, maybe it's not true, but it's really not to try and get benefits.
Yeah.
Well, I think that the most blatant, and unfortunately I've had these come in my practice, is where the injured worker or alleged injured worker is stating that he cannot work at all, and he's receiving the temporary total disability benefit for being disabled completely, and on the side he's working secretly. And sometimes the investigators catch them out there.
And that's a clear-cut example of fraud under 23:1208.
That's correct.
Oh, you know, this is something that we did not talk about during the last show, but in doing some research for this, I did come across this information about video surveillance and private investigators. Are those par for the course when it comes to these workers' comp cases?
I would say that yes, par for the course probably doesn't sum it up, Ms. Shauna. I think that they're used a lot in our cases.
Yeah. All right, well, what's an example of fraud where you say, hold on a minute, Mr. Employer, well, maybe attorney for the employer, are you serious that you're calling that an example of fraud and you're trying to cut off this injured person's benefits based on that? Give me an example if you've got one from real life.
A person, I handled a case where a gentleman was 54 years old and he was claiming a neck injury on the job. He gave a recorded statement before he retained me, and they asked him the question, have you ever treated for your neck before? And that question is so broad, but he didn't think about it, and he said no. And they did find records when he was 17 years old. He was playing high school football, and that was used to deny his benefit.
Wow.
So the employer denied his benefits, and they said that's the reason. Did he have neck surgery when he was 17 years old? Or?
No, he did have a neck MRI. Okay. He did suffer an injury when he was 17 years old. But I honestly believe my client did not knowingly and intentionally make that statement for the purpose of obtaining a benefit. Unfortunately, the judge didn't agree with me on that case.
Unbelievable.
That is unbelievable.
And was there a real neck injury in this case, as
Yes,
far
there
as you
was.
could tell?
Yes, there was.
Okay. And frankly, for what it's worth, I've seen that too, even in personal injury cases. It seems less than honorable in my humble opinion.
a lesson learned there is if someone asks you about your medical history, you need to disclaim to the fact, to the best of my memory, because I don't think that if I were challenged today, I'm only 49 but soon to turn 50, that I could give you a comprehensive medical history.
Yeah. I mean, I've seen it so many times where somebody goes, well, what about this when you were a teenager? Oh, wow, I completely forgot. So it's wise advice. If you're the person trying to make a claim and you're not up to shenanigans, say, best as I can remember, I don't think I have had a problem with my neck or back, or nothing that serious that I can recall, because if that's always tell the truth, always tell the truth.
Yeah, because
always
these
tell the
investigations are very thorough. I mean,
Yeah.
to go back to, 17? He was 17 years old when this injury happened,
That's what,
and to find that
30
information, so
years, no,
very thorough
37
investigations.
years earlier, goodness.
Yeah, yeah. So let's talk a little bit about remedies, because we really didn't get into remedies the last time as well, and I know that's very important, and you wanted to make people very aware of the different types of remedies.
What are your remedies if you get hurt on the job?
Well, your remedies are, we briefly touched on it. There's the medical treatment, and medical treatment is considered what is reasonable and necessary. And now we have what's called medical treatment guidelines. Recent decision in Dardar says that they don't apply to everyone. So if you were hurt on or before July the 11th of 2011, you may have a different medical process or a process to go through to get your medical treatment approved
This is a
than
big
after.
change in the law.
Yes,
This
it
is
was.
a big change in the law. Anybody who's an attorney who dabbles in work comp, number one, you should probably involve somebody like Mr. Murray. Big change in law. So if you're hurt before July 2011, it's one way that injuries are determined, what treatment you get, and then and if you're hurt after that date, it's different.
All right. Recent decision from the Fourth Circuit Court of Appeals tells us, and you have to remember, Shauna, that, and the viewers, that as to that area of the Fourth Circuit, there's still circuits that have not weighed in on whether these medical treatment guidelines are retroactive or prospective only, meaning will they apply backwards. So right now, where our argument is, it's the date of injury as to what will determine it. So there are two different processes to get your medical treatment. Your medical treatment that you will receive is made until you're cured, or you reach what's called maximum medical improvement. You may hear your adjuster saying MMI. That's the term that the lawyers and the
That's as well as you're going to get.
Yeah, in accordance with your doctor, there's no further medical treatment they can get to improve you. That medical treatment can last for the rest of your life. It's an obligation. It usually doesn't practically fill out that way, but your medical treatment will prescribe. You won't be able to make a claim if 3 years go by and you don't have any medical treatment paid. The indemnity portion, and I'm going to use this word indemnity, this is the check.
Wages.
Yes, your wage loss is going to be capped statutorily. That means the law every year on September the 20th, they announce what's the maximum you can receive. Ideally, a person shall receive 2/3 of their wage under workers' compensation law. And it's important that you break this down into temporary total disability, because when you're being paid temporary and total disability, that means you're going to receive the full 2/3. It means you're not working at all. But if your doctor were to say maybe you can go back to work, but only 20 hours a week, or your employer makes accommodations, which many times happens, then you go into what's called supplemental earnings benefits.
Okay.
And if in your ability to return to work, you can only earn, if you earn less than 90% of your pre-accident wage, you'll be entitled to 2/3 of your actual wage loss.
And accommodations, meaning light duty work. If your employer says, don't worry, you won't have to lift anything heavy, well, whatever the doctor says you can do, we'll provide work that allows you to work within those restrictions.
That's correct.
Light duty.
Now, there's the other more tragic is the death benefits. Sometimes on the job, people lose their lives. And when that happens, in short, what you should realize is the spouse, a legally married spouse, is entitled to an indemnity wage benefit. It's a low percentage, and she's entitled to it for the rest of her life, provided that she never gets remarried. If she remarries, it'll stop. Dependent children may be entitled to even a 13.75%. Trust me, these calculations run workers' comp lawyers crazy. Until they reach age 18, unless they're in college, an accredited college, they can get up to 22. Also, there should be a funeral benefit paid to the dependents. If there is no wife or no eligible dependents, then each parent is entitled to a one-time payment of $75,000.
Okay.
In addition to that, you may have a catastrophic injury, and those have a one-time payment in those accidents where people lose both hands, both feet, or one of each, or both eyes.
Oh, wow. Okay, we'll talk a little bit more about that. Plus, we're going to get our viewer questions in. Believe it or not, it is time to get those questions in. When we come back, we'll take your questions about workers' comp for our guests, so stay tuned. We'll be right back.
am for the child who lives in motels, cars, and shelters, now in foster care, a group home, where he sleeps not on a bed, but on a temporary cot. He is the child I am for. I am a CASA volunteer. I am you.
Hello, everyone, and welcome back to the show. We are talking about workers' compensation, and we want to hear what you have to say. You have some great questions, and so we're going to get right to it for our guest, Attorney Ray Murray here. Now, here's a question from our viewer who says, what if my employer wants to pay me workers' comp, but the insurance company doesn't agree? Then what happens?
If I understand the question correctly, is the employer wants to pay a wage in lieu of them receiving workers' compensation benefits?
I think so.
Well, I think one of the things they ought to consider is that might have some tax ramifications. If I understand it right now, the disability payment is not a taxable income, and that may be something they want to consider before they start accepting money from the employer. In isolated cases, I've had cases where people have actually contracted with their employer that they would receive a supplement in addition to the workers' compensation benefit paid by the insurance company. I would probably in most cases recommend that you deal with the insurance company. They're more experienced. And the other thing is as this leads towards settlement and finality, things must be filed in front of a workers' compensation judge to be closed.
Well, one of the other questions that we have too is, can a person work and receive workers' comp?
Yes, they can, if they report the income that they're receiving, and if they may still receive a supplemental earning benefit. You should not be receiving temporary and total disability and doing anything to earn wages. If you're capable of earning wages, you need to let the adjuster or the defense lawyer know that so that they can take account, and you need to tell them how much you're earning and be honest about it.
Again, we're getting back to that honesty thing.
Yeah.
Always be honest.
Well, and just so we're clear, in other words, let's say you're able to make $500 a week before you get injured. Workers' comp owes you 2/3 of that. If you're able to get some other job, and maybe before you were doing heavy lifting, and you find some other job answering the phone, and you can make as much money. Well, workers' comp doesn't owe you anything because you're able to make at least as much, or if you can make 90% of what you were making before, then your other job doesn't owe you anything, correct? Not in wages, not in indemnity benefits.
You would still have your medical benefit, but you
Still owe
shouldn't
for
receive any money.
whatever medical care you need, no matter what. But if you're able to get some other job and all you can make is 50% or 1/3 of what you were making before, since you're supposed to make 2/3 of what you were making, then they would owe you another 1/3 of what you were making before. I mean, I don't mean to do a math test on you right now, but in other words, whatever you were making before, you should be able to make at least 90%. So if you're able to go back to work, I misspoke, you should be able to make, the employer should supplement whatever your income is, so you make 90% of what you were making before.
We'll do the 500. And so if a person can make $450 a week, they're not entitled to anything because they're making 90% of their pre-accident wage.
Right.
However, if he can only make $300, then he has a $200 a week wage loss. And you would simply double that number and it would become 400 and then divide it by 3 and it'd be $133 a week that they'd be entitled to. In addition to the $300 they're earning in employment.
You know, just a second ago, you mentioned settlement, and we're talking about, settling. And again, I want to get back to the timing. I want to get back to the whole timing issue when it comes to the settlement. But how do I know if I have gotten a fair settlement?
First thing I would tell you is seek legal counsel and have someone evaluate the claim or evaluate the offer that's being presented to you. What you want to do is you want to take account of the remedies available to you. If there's any penalties and attorney's fees, you want to also make that part of your demand towards settlement. And as I said earlier, or actually said in the last show, a person can represent themselves. If you have a settlement in workers' comp and you're representing yourself, you will go before the workers' compensation judge. And she's going to ask you questions, or he's going to ask you questions as to whether you understand the ramifications and the consequences of making this settlement. And it can be performed there. Generally, the insurance company will tender you the check on the record in the courtroom. If you have a lawyer, you won't be required to go to the courtroom. The lawyer can file that for you as to the settlement. But I do think that anybody who's contemplating doing a full and final settlement of their workers' compensation claim, considering the fact that they may have medical treatment for the rest of their life, should seek out legal counsel before doing so.
Yeah, and one of the benefits of having a very capable lawyer representing you in a workers' comp case is so often it happens that the employer or the insurer for the work comp employer hasn't done what they should have done. And so there may be the opportunity to go after that work comp insurer for penalties. That's extra money on top of what wages are due to the injured person. And a lot of times that insurer's got to pay the lawyer fees separate and apart from what's owed, and that's money that's not subtracted from what goes to the injured worker, right?
That's correct. Attorney's fees can be assessed by a judge if the claimant, the adjuster, doesn't adjust the claim reasonably or makes decisions that are arbitrary and capricious without
and you
support.
can even work that out in a settlement.
Yes.
And getting to lump settlements, maybe that's worth talking for a minute. The lawyer is able to look at what similar injuries are worth, assuming you have a good idea what the long-term prognosis medically is, because you've looked at the medical records, maybe you've been able to talk to the treating doctor, and you know medically, maybe the person's done treating and there's a long-term injury that they just have to deal with, or you have a good idea of the prognosis. You can get a good idea of what this case is worth over the long haul. Either they get their benefits every week or they're likely to get them for a long period of time. And you can actually put pencil to paper or use a calculator and come to an approximate value of the case and come to a lump settlement. Is that something that, and one possibility is you can get a lump settlement and be done with the case sooner rather than later. And sometimes that's a good idea and sometimes it's not, correct?
In most terms of benefits, when we're talking about the indemnity, it's limited to 520 weeks of actually taking. There's a time limitation.
10 years.
I like to say 520 weeks because it may be interrupted. It may not just be 10 years continuous. It may be 52 weeks and then he goes back to work for 6 months and then he goes back out again because of medical treatment. And what we want to do on that is you need to understand the term present day value. It is a reversed interest rate that's used by the insurance company. Kind of the idea is if I give you this money today and you were to invest it, you'd have more over than you would have at the end of 520 weeks. So therefore, they're allowed to reduce it. The maximum under law is 8%. If you don't know how to calculate it, seek out an attorney that can help you with the calculation of that. There is no pain and suffering. It's going to be limited to the indemnity value and the medical value. Briefly, I'd like to touch on the idea. A lot of clients, when you talk about people that cannot go back to work, it's going to be a long-term thing. Yeah. They may want to consider applying for Social Security. You may draw workers' compensation and Social Security at the same time. You're not going to draw them both full. One will take a credit for the other depending on fact-specific as to your injuries.
Now, at what point do you tell your clients or would you advise someone to make a claim to receive those Social Security disability benefits?
While they're on workers' compensation, I generally tell people you have to be out of work for 6 months before you're going to qualify for your Social Security disability. This is for people who have worked, they've paid in the 40 quarters of Social Security. But you also need to understand that when you do that, if you become Medicare eligible, you cannot settle your workers' comp claim unless the insurance company puts up money to protect Medicare's interest. They generally open an annuity or trust fund for that injured worker to protect Medicare's interest. And that's by federal law.
Okay. All right. Well, we have so many questions from our viewers. We have another one here that says, can my employer fire me because I was hurt on the job?
And the short answer to that, Shauna, is no. There is a law out there, specific law 23-1361 if memory serves me, that says that's a retaliatory discharge. However, I caution the viewer that any other reason, because we are, I believe they term us as a right-to-work state or
fire at will.
You fire at will.
Hire and fire at will.
Well, the problem there is that in my career, I've had 2 cases where I successfully litigated on that, and it was through huge error on the part of the employer where they actually said, because you file workers' comp, we're going to fire you. It's short of that, I've not had a very good success rate. I generally refer those out to an employment lawyer, or I have a series of employment lawyers, but you're not supposed to be fired, but jurisprudence tells us that a person who was confined to a wheelchair was fired for absenteeism. They said that wasn't because he filed a workers' comp. That was because he was absent from the job, albeit that he was unable to get to the job site. So it's a very limited chance of recovery.
But can you speak a little bit to the fear that some employees have out there, you know, that if they do file a claim that somehow it is going to send a bad message or signal out there that, you know, they might face some sort of retaliatory action from their employer, or if they try to get future employment that, you know, this is not going to be a good thing to have on their record?
both of those things are outstanding problems, and that there are employers out there that will make accommodations for 1 year and 1 day and then say you're fired. It's a very steep uphill battle, but we can argue that if they made accommodations for you and you're under restriction, that they were paying you wages in lieu of compensation, and therefore your time is not run out to make your claim. A large number of my clients will be asked to voluntarily resign as part of their settlement in workers' compensation. It seems to be a sin that you cannot recover from with some employers. As far as future, federal law dictates to us that you're not supposed to ask people about their medical history and stuff. However, there is a form in Louisiana called the post-hire pre-employment form, and they do ask you about your previous medical history and if you've had workers' comp claims, but that should be limited till after you've been hired. You shouldn't be asked to fill out that form when you're applying for a job.
Okay, now we're running really short on time here,
Yes,
so
ma'am.
one more question. This might be kind of a big one, but I'd love for you to touch on it. This question says, what if I am not a legal resident? Can I still file a workers' comp claim?
Yes, I represent a large number of undocumented workers, and most of them, the vast majority of them, are Latin people. As John and I work together, we both speak Spanish. No, workers' compensation is the remedy that protects the employer. When you deny a person being an employee, and this is very important for the employers, then you may open yourself up to a full negligence case. So therefore, in our state, our Constitution and the law as it's written says any person that is injured on the job. And that includes, there's no alien or other status that takes that away from you.
Okay.
More important that the employer realize
Okay. That any person.
that any person, and the minute you say he's not your employee, then I might be calling someone like John Redmann to assist me in a regular negligence case against them.
All right, they're saying we got to wrap. Thank you so very much,
Thank
Attorney
you for
Ray
having me.
Murray, for being with us for these two shows. It's been really great. We've learned
Thank
a
you
lot.
very much.
It has been quite a learning experience for us here on Power of Attorney, and we certainly hope that you have learned a lot as well. Be sure to join us next week when we will delve into yet another hot legal topic. Until then, be sure to visit us online.
Thanks, everyone, for watching us today. Be sure to visit johnredmondpoa.com for more information about workers' compensation, other important legal topics, and send in those legal questions and show suggestions. And don't forget to follow us on Twitter and Facebook. We'll see you next time, and for more shows on more topics on this show. Thank you very much.